Hi, good day, and welcome to the third module of our security management series. This is entitled Legal Issues and Computer Forensics. My name is Justin David Pineda, and let's start. Dura lex sed lex. This is a legal maxim that says the law is harsh, but it is the law. So, when IT professionals, IT security team gets involved with investigation of potential cybercrime, they are objective and they see to it that all the required information and processes are followed. All information are provided accurately, and that they will interpret it as how they're supposed to do it in their normal day-to-day processes. Okay, so biases aside, um, they will do the task in conducting investigation as objective as possible. Okay. So what is a cybercrime? So we say that it is any crime in which the computer-related technology is encountered. So there are um, and three three scenarios. So the first one is it's a crime directed against a computer. Okay. The second is where the computer contains the evidence. And the third one is the crime where the computer is used as a tool to commit the crime. No? So it's like, so the first one is that um, here it's when the computer is the target. Okay. The second one is when it contains the evidence, meaning it's not directly involved. This is what we call as incidental. And the third one is when it's used to commit the crime. It's what we call as the source. No? So the computer as the source, the computer as the target, and the computer as incidental to the crime. So in order for you to determine the cybercrime, you need to determine the scenario. Okay, what's the purpose of the computer in the commission of the crime? Okay, so why commit a crime or particularly cybercrime? So we go to these are acronym MOM. So motive, opportunity, and means. So this applies even to the normal crimes. Okay, so motive, so the who and the why of a crime, the opportunity, the where and the when of a crime, and the means, the abilities a criminal would need to be successful. And it's easy to do an MOM for when you do your assessment, your risk assessment. So we discussed this in the first module. So you can establish this when you do your risk assessment, determining the threats, and then determining the risk rating. So the higher the risk, okay, it's either the higher the motive, okay, the bigger the opportunity because there's a vulnerability, and the higher the means, meaning there are a lot of sophisticated tools, or maybe not sophisticated tools, but tools that can use to commit a crime. So you need to determine the MOM, okay, in you know um, checking the possibilities or the risk that a crime might happen in your organization. So what is the connection between legal and forensics? Okay, so when we say forensics, it's the application of scientific knowledge to legal problems. So we actually use forensics not only, um, well, primarily in investigating um, in crimes and investigations and um, in doing post-mortem, etc. So we do forensics. So we also apply it here in IT security in the virtual world. and use this to solidify an evidence if it's going to be presented to court. So that's the process. So when we say computer forensics, okay, a type or um, a type of forensics that involves preservation, identification, documentation, and interpretation of computer data. So the methodology of forensics remains the same. It's just that we do it in with a computer, no? With an endpoint, with a network device. So the purpose of computer forensic investigate and analyze computer systems as related to a violation of laws. So so we're not lawyers, but that the provisions in cybercrime laws are very straightforward, okay, in matching if or in defining that cybercrime is committed. Okay, second, investigating and analyzing computer systems for compliance. So we also do this in a way you can audit if processes are followed correctly. Okay, if the checklist that needs to be followed are done, okay, routinely and consistently. Okay, and last would be investigating computer systems that have been remotely attacked. So this is also popular. Okay, and the MOM might be different. Okay, you may have a list of motive. Probably there's no direct inclination. Um, just somebody who would like to test. Okay, script kiddies testing some tools, and then it so happened that one lucky day they were able to test a vulnerable system, and it got remotely attacked. Okay, so these are the things that we need to be able to conduct forensics on to determine if data is stolen, if you can trace the perpetrators, etc. Okay, so here's the incident response process. So we have um, 1, 2, 3, 4, 5 steps similar to the SANS methodology. Okay, so here in the incident response process, it says that if there is a security, we qualify it as security incident, okay, because incidents may not be security incidents, but here we're talking about security incidents now. That we need to be able to follow a process um, in dealing with different types of security incidents, because some security incidents might lead or might be considered cybercrimes already. So the steps are: first, discover and report. So employees should be trained to report incidents. So there are two ways. Okay, so it's either the employee will report an incident that they have discovered, or it is the security team that has discovered that there is a security incident, and these things have to be reported. Okay. The second step would be confirm. So the responders must acknowledge, no, that there is an incident. So um, responders can be coming from the IT team, can be a triage, can be a help desk that will classify and determine if it's a regular incident or a security incident. Security incident. So if it is a security incident, confirm and then route it to the security team. Okay, so the third step would be investigate. So the specialist must be able to determine the extent of the incident. Okay, is this uh, um, um, an isolated case? It only occurred on a single device, or um, did it spread to the network, etc. So the specialists, the analysts are trained to determine that. Okay. And the next would be recover. So when the investigation is complete and documented, return systems to operational status. So how do you do it? We discussed this in in the last module in business continuity planning, we said that there's there's an RPO, recovery point objective. There is a maximum tolerable downtime, which consists of the RTO, recovery time objective, and working recovery time. Okay, and enforce the whatever policies that we have. Some organizations will require that the computer be wiped out. Okay, some rely on the output of the anti-malware installed, so we have to follow that. Okay, and last would be lessons learned. So discuss points of improvement to correct the mistakes. Okay, so record everything. If this is the first time that this event happened, you can create a playbook. Okay, or document the correct process and determine later on, conduct a root cause analysis. Why did this happen? And then tweak or customize your policy. Okay? How about evidence? So when we say evidence, so these are documents, verbal statements, materials admissible in a court of law. This is very strong. But there are different types and different levels of evidence. It is critical to convincing management, juries, or authorities that a violation has occurred. So similar, and you may be encountering this in um, even in the organization level when HR asks, HR will send a notice if an employee is accused of committing an infraction or a violation in the company policy. They have to get an evidence. They have to investigate further, and they need the help of the IT security team. So the IT security team will not pick a side, but instead will go straight into evidence gathering and present it as is. Okay, provide expert opinion if necessary to provide a fair assessment whether or not a violation has been committed. So even in the organization level, there is due process. Okay. So why is it hard to present evidence that is computer based? So this is very obvious. Okay, so we say that it's very hard to equate physical and virtual assets, which is true. Up to now, for the boomers, for the old people, we say it's better to have, or it's different, a 1 million peso or $1 million worth of money that is tangible is different from $1 million um, in an online account. Okay, so some people still think that way, that these are two different things, but when in fact they're the same. Okay. Um, Second, cybercrime does not follow the evidence and case handling in the usual courts because okay, you can commit, you can set a logic bomb, you can set a time bomb on weeks ago and launch it today, and the usual the usual questions that are asked in the court is where were you when the event happened, etc., etc. So you could have planned it way back. Okay, trigger allow somebody to trigger it without them knowing, and you walking out freely. So this does not follow the normal process case handling or evidence handling. And last would be jurisdiction. Okay? And that's the reason um, why P2P sites, peer-to-peer torrent sites are still prevalent, even if they host um, materials that violate intellectual property laws because they do not have these laws that protect software applications, media against piracy. So jurisdiction is still a very big issue. Okay. So standards for evidence. So you have um, uh, to undergo this criteria in weighing if the evidence, um, to say that the evidence is strong. So the first one is sufficient. So meaning the evidence must be convincing or measure up to without question. Okay. Second is competent evidence. So the evidence must be legally qualified and reliable. And the third is relevant evidence. So the evidence must be material. Material meaning um, related, or um, relevant, pertinent to the case and have a bearing on the matter at hand. So you cannot just pull some materials that are not related to the matter. So, so it has to be relevant. So some of the key questions in evidence control. This is for computer forensics. Who collected the evidence? How was it collected? Where was it collected? Who has had possession of the evidence? How was it protected and stored? And when was it removed from storage? Why? Who took possession? So the process of collecting is at a different phase. Preserving the evidence and passing it, um, following the correct process is another. So that is the and these questions would be asked in trials or in hearings, and um, it has to be convincing. It has to conform with the process. What are the types of evidence? So we have direct, real, documentary, and demonstrative. So when we say direct evidence, it's an oral testimony that proves a specific fact, okay, which is obtained through the five senses of the witness. I saw it, I heard it, I smelled it, I felt it. Real evidence, associative or physical evidence, so tangible evidence that prove or disprove a fact. Like this is the material used, okay, this is the knife used to kill, with the blood stains, etc. Okay, so the third is documentary evidence, business records, printouts, manuals. So a lot of evidence related to computer crimes fall under documentary, policies, record, etc. Fourth is demonstrative evidence used to aid the jury through models and charts, not so strong. Now, there are also rules in evidence handling. Okay, so the first one is the best evidence rule. So when we say best evidence rule, the court prefers original evidence rather than a copy to ensure no alteration has occurred, which is which is understandable. So that's the first rule, best evidence. The second is the exclusionary rule. It prohibits the use of illegally obtained evidence. That's why um, in computer forensics, chain of custody is a very important concept and must be um, followed religiously. Okay? At the same time, okay, the reason why there's an exclusionary rule is to provide due process on both parties. So you cannot, so you accuse him of stealing, but you stole the evidence from him. So it has to go to the correct process. Go to the police, um, have them investigate, etc., etc., and go to the court and get a search warrant to search the place, etc. Right? Now, the third one would be the hearsay rule. It's called the second-hand evidence. It's an evidence offered by the witness that is not based on personal knowledge. Okay. So this is when we say second-hand, meaning this is not a strong because it's hearsay. Now, where will computer-generated evidence fall? So by default, it will fall under hearsay because the maker of the evidence, which is the computer, cannot be interrogated. You cannot um, put it in a witness stand and ask for uh, um, yeah, as whether it was altered, etc. or not. The only exception is when the computer in question generates the data as part of a followed process routine of the organization. So if we establish that there is a process of collecting this information, usually if there is a policy, eh, and then there's a process, and then there's the technology, and then you show that these things are um, uh, that collection of logs is a normal thing for the endpoints, and these logs are reported to an SIEM and then correlated, aggregated, etc. Then okay, that would be an exemption or an exception. We mentioned this in the information security, general security concepts, and organizational security, JUCA and due diligence. So this is also applied in legal issues. So when we say due care is the thought, okay, that minimum customary practice of responsible protection of asset, and due diligence is the action. So when um, an event, an incident, a security incident, a crime happened, okay, this also asks, did the organization exercise due care and due diligence to, for example, um, to enforce a policy? Okay. Did you put the necessary controls? Did you inform and communicate these things to your employees, etc.? So this will be asked, and they should have exercise due care and due diligence in the best way possible. Process guaranteeing fundamental fairness, justice, and liberty in relation to individuals' legal rights. So we say that a suspect is innocent until proven guilty, right? So there's a due process for that, and depending on the crime, maybe a civil, okay, or um, maybe a civil case, it may be a criminal case. So and the burden of proof may be different depending on the type of the case. So, but due process must be enforced. Okay, so now let's go to proximate cause. So it's an act or omission, okay, that naturally and directly produces a consequence. So this happens when yeah, so there's an action committed not directly by the organization, okay, but there are actions that are committed or that happened wherein the organization has a legally recognized obligation. So, for example, there's a data breach. You cannot just say our data processor is a third party. Okay, so still you're facing your customers, and it's your customers' data that have been breached by the third party. So basically, you still have an obligation, okay, because your reputation is at stake, because you have contractual obligations on between you and the customer, etc. So we call it proximate causation. Okay, so in this lesson, we will not study specific laws. Instead, we will be discussing specific assets that organization wants to be protected or wants to protect. So we discuss the different laws in InfoSec series. So here we're going to discuss uh, the assets. Okay. So usually it's the organization's intellectual property. So we discussed this in risk management, right? That when we compute for the asset value, we compute for the value of the laptop, but the information that resides in the laptop may be very or way more expensive than the actual cost of the laptop, because the information may be the bread and butter of the organization. Okay, so that's one. No? So that's why we have to study the different um, types of intellectual properties in IT. So intellectual property laws do not look at who is right or wrong, looks at how a company or individual can protect what it rightfully owns from unauthorized duplication or use, and what it can do if these laws are violated. So it's different because intellectual property, again, this is not tangible. Okay? And it's very easy to duplicate it. Okay? You borrow a book, you go to the photocopy center, you photocopy the book, and that's it. Okay? You already have a copy of the information. Um, and then there are different now in IT in the virtual world, it's easier to duplicate it. Just control C and control V. You already copy pasted the material. So some of the categories include industrial property such as inventions, okay, also called patents, industrial designs, and trademarks. And the second one would be copyright. Okay. Excuse me. So we start with trade secret. So when we say trade secret, okay, well, the first characteristic of a trade secret is that it must have a competitive value or advantage. Okay? And second, it's something proprietary to a company and important for its survival and profitability. So the example is Coca-Cola. So they have their trade secret, the formula of Coke. So it's necessary, okay, for the company's survival and profitability. So it requires special skill, ingenuity, or expenditure of money and effort. So these are the characteristics to consider this as trade secret. So it has no expiration date unless information is no longer secret or no longer provides economic benefit for the company. So that's a trade secret. Copyright. Okay, so it protects the right of an author to control the public distribution, reproduction, display, and adaptation of original work. Okay, so pictorial, it can be graphic, musical, dramatic, literary, etc. It protects the expression of idea of the resource instead of the resource itself. So it's the protection of the expression of idea of the resource, but not the resource itself. So it's weaker than patent, but the duration is for life plus 50 years economic benefit for the company. Okay. Then next one is trademark. It's used to protect a word, a name, a symbol, sound, shape, color, or combination. So you register your trademarks too. Okay. And patent. So when we say patent, it's given to individuals or companies to grant them legal ownership of and enable them to exclude others from copying the invention covered by the patent. So the characteristics, it should be novel, okay? It should be useful and not obvious. So you cannot patent um, yeah, you cannot patent um, obvious obvious inventions, no? Like scissors. Yeah, it has to be novel and not obvious. Usually, patent is up to 20 years after approval date and it becomes public domain. So this is the strongest form of intellectual property protection. Okay. So to summarize, these are the different intellectual types of intellectual property. We have trade secret, we have copyright, we have trademark, and we have patent. Now we go to entrapment versus enticement. So what is the difference? So when we say entrapment, it's when the law enforcement or an agent of law enforcement persuades someone to commit a crime when the person otherwise had no intention to commit a crime. So this is uh, there's a common misconception because in the news, uh, it's always entrapment. They use the term entrapment, but it has a different meaning. So when you entrap somebody, you're trying to, okay, persuade someone to commit a crime, but the person has no intention to commit it. Like for example, you go to a website and the website is the library, and then there's a link. The person clicks the link on the library because the person would like to search for a book, but when you click that, it actually downloads a lot of malware. It triggers a lot of malware. So that's entrapment. Okay? The person has no intention of downloading it. Okay? So the second type is enticement, wherein the agents of law enforcement making the conditions for commission of a crime favorable, but the difference is that the person is determined to have already broken a law or is intent on doing so. So for example, there's all the bypass operation. So that is enticement because the person um, uh, has the intention of buying, for example, drugs, and then they will entice him to buy, okay? And then they will mark it as an evidence, etc., and then catch them, the person in the act of buying or carrying it or something. So these are the differences between entrapment and enticement. Okay, so computer forensics methodology. Okay, so um, we will not go to the details of computer forensics because there's another course for that. Okay, but the methodology are the steps are as follows. So that number one, you need to obtain a search warrant unless there is unless there is consent or okay, there are exemptions. But let's stick to these default steps. So you obtain a search warrant. Second, you evaluate and secure the scene. Third is collect the evidence. Fourth is secure the evidence. Five is acquire the data. Six is analyze the data. Seven is assess the evidence and case. Eight, prepare the final report. And nine, testify as expert witness. So we we call it amicus curiae when when you are asked to go to the court as an expert witness. Okay, so they are going to ask for your opinion because computer forensics is technical. Okay, so they might um, have a hard time understanding the technicality, so they need an expert witness. Okay, so computer forensics methodology summarize. So you acquire the evidence, you authenticate, and then last would be analyze. So these are the steps. Acquire evidence without modification, authenticate the recovered evidence, okay, um, and compare it, so compare hash values, etc. And last would be analyze. Analyze data without alterations. So these are important steps, and it has to be emphasized periodically. Okay. So yeah, when do you not need a search warrant? So again, this is what I mentioned in the methodology. Okay. So these are the um, exemptions. So number one, there's a consent. Okay. Don't need a search warrant. Second, there is an exigent circumstances, there are exigent circumstances, meaning um, that you need to do it because if you do not do it now, you might lose the evidence. Okay? Um, for instance, when dealing with computer, so if the battery is running low and you need to get whatever it is in the memory, so that's exigent circumstance. So you have to get it now or never because once the device goes off or turns off, the contents in the memory will be erased. So you have to decide. Third would be inventory searches. Fourth would be international issues. Okay. So These are two very big things: the inventory searches and international issues. Um, the fifth one would be search incident to a lawful arrest. Okay, so um, it's either uh, you are caught, okay, um, in plain sight that you're you have committed a crime, okay, and for the police to prove that you stole something or you use a gun um, or other tools, then a search must be conducted. So that's search incident to a lawful arrest. And last one would be border searches. So these are the instances when you do not need a search warrant to search. Okay? So here it says if you are not a lawyer, you are not a lawyer. So you're not going to provide legal opinion, advice. You're there in the organization to conduct whatever process or processes um, required or are expected of you. So when you collect evidence, so these are the steps. You acquire the evidence, identify the evidence, protect, transport, and then store the evidence. So acquiring evidence, collect evidence as soon as you can. Okay, so again, these are the layers, the types of um, storage media based on the data volatility. So the most volatile of them all is the CPU storage, okay, then RAM going down. That's why you need to. That's why I mentioned exigent circumstances a while ago. Okay. So should you turn off a computer when acquiring evidence? This is there are schools of thought about this. No? So some says that you have to keep it on because um, you need to get whatever it is in the memory. However, um, if you let it on, then if there's a malware, it might spread or it might infect the ones that you're trying to save. So yeah, so it depends on the situation. So data in the memory may be crucial in your investigation and there may be loss. So should dumping of physical memory be done? So ask for legal advice first. Follow your policies, company or incident response processes. Um, and you follow it because it will vary depending on the organization. If it's a bank, the process will be different. If it is, again, if it's a hospital, it will be different. Okay, so you need to ask for legal advice first. Okay, so this is more um, applicable for your investigative work. Okay, because for us, we know the process, we know the steps. Okay, but once we do not conform or we do not follow the first step, then all the steps should be forfeited, whatever the outcome is. Mm. So for consistency purposes, so these are the default setup. Okay. So memory should be dumped. Number two, system should be powered down clearly. Number three, email should be made and used as you work. Number four, never examine a system with utilities provided by itself. So these are the default that we will be using. So it will depend. So it may be customized later on depending on the organization. So what do we say when we should system powered down clearly? Okay, so shut it off. Okay, and do not go to the start shutdown and then um, click the shutdown button because it may download, it may trigger some processes, okay, and may harm the evidence and harm the evidence. So you can just plug plug off the the machine, do a um, hard stop. No, you can press or hold the power button to shut down the machine. Identifying evidence, so properly label and store the evidence. Make sure labels can be easily removed. Okay, do not collect evidence by yourself. Okay, and keep logs of your actions during seizure, analysis, and storage. Protecting evidence, so protect evidence from electromagnetic or mechanical damage. Ensure evidence is not tampered or damaged. Okay. There's also what we call the radio frequency isolation bags, okay, that are used for protecting the evidence. Next would be transporting the evidence, so properly log all evidence in and out of the of controlled storage. And then storing evidence. Evidence room should have low traffic. Usually it's the innermost part of the premises. Restricted access, camera monitoring, and entry logging capabilities. So these are the default or baseline. Okay. Observe proper packing techniques, static-free bags, foam packing material, and cardboard boxes. When conducting the investigation, so the rule of thumb, a copy of the system should be analyzed, never the original system. That's the rule of thumb. So a good forensic process will prove that the forensic copy is identical to the original. Okay. So investigators usually use the forensic copies, okay, and will use these types of tools. So these wipe utilities, file viewers, forensic workstations, okay, hard drive tools, and unerased tools. Okay. And these are the steps no, in conducting the investigation. So, um, yeah. So I'll skip this and let's go to chain of custody. So in chain of custody, so evidence must be properly controlled to prevent from tampering. So that's why you have the chain of custody document and everything is listed there. Received from, received by the date, the time, and signature, okay, and the details. Account all persons who access or handle the evidence. Okay, so again, this is the process. I'll skip this. You can just um, check this thoroughly later on your free time. So another issue is when you delete something from the hard disk. So when you delete, a pointer in the file allocation table is deleted, not the actual file. So we talk about free and slack space. So when we say free space is the cluster in the disk that still holds a fragment of the original file. And the slack space, wherein it's an excess space and an allocated space for a new application. So why do we need to talk about this? Because there are unerased tools during evidence gathering, evidence collection, wherein you need to use these tools to get pieces of the puzzle and see what you can recover. And if there are pieces of evidence that can be used for analysis and presentation to the law enforcement agencies or law enforcement officers. Okay, so analysis, you check the recycle bin for deleted files, you check the browser history and address bar history, so check the web browser cookie files, temporary internet file folders, okay, search for suspected character strings, and search the slack and free space for suspected character strings. Okay, so yeah, so this is just a crash course on legal issues and computer forensics. To review, okay, so protecting evidence and providing accountability for who handled it at different steps during the investigation is referred to as what? So the answer is the chain of custody. Which type of intellectual property is focused on maintaining brand recognition? So brand recognition, so that is a trademark. Right? What type of evidence is provided by a witness that attests to something that he experienced with his five senses? It's direct evidence. which principle requires that an organization's stakeholders act prudently in ensuring that the minimum safeguards are applied to the protection of corporate assets? So the answer is ensuring that the minimum safeguards are applied. This due diligence. And then last, why is it challenging to collect and identify computer evidence and to be used in a court of law? So evidence is mostly intangible. The evidence is mostly corrupted, mostly encrypted, mostly tangible. So the answer is the evidence is mostly intangible. Okay. So this sums up the discussion for legal issues and computer forensics in the perspective of security management. So again, um, this does not only apply to external um, facing laws and policies, but this can also be applied internally in the organization, within the organization. So the computer forensics process okay, um, can also be applied and can be implemented internally and use the same tools. Okay. Because not every day there is a cybercrime involving somebody from the outside targeting your organization. Okay. But you can also apply computer forensics when um, investigating internal issues, especially the ones that are raised by HR. Okay. So thank you very much for listening. If you have any questions, you may comment it um, or send me an email at justinp@pinedacybersecurity.com. Thank you very much and see you in the next module.